Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, hope you're all well. I've got 3 cases to talk about today, but actually given the timing of this episode, I thought it would be remiss of me not to mention first the company law and company's house changes that came into force on the 18th of November. So if you remember, I have talked about this before, but the headline change is the new requirement for individual directors and PSCs, persons with significant control, to verify their identity. Now, according to a Companies House press release, about 1.5 million people have already done this, so that's great. But actually, that still leaves a significant number that have yet to verify that. I think the original estimates that I saw were that there were about 7 million people that were going to be affected by this. So the new requirements already apply now to all new appointments and incorporations. So you have to confirm that a director's identity is verified when notifying Companies House about a new appointment of that director or a new incorporation of a company. And for the PSCs, you can confirm that their identity is verified at the same time. But if you don't, then Companies House will write to them and ask them to do this within 14 days. For existing directors and PSCs that were in office on the 18th of November, there's basically a 12-month transitional window during which broadly they need to complete their identity verification and confirm that to Companies House when the company files its next confirmation statement. The other changes that came into force at the same time relate to the registers that a company has to maintain. So, in particular, a company no longer has to maintain its own internal registers of directors, secretaries, and PSCs. Instead, what the company has to do is file all the relevant information at Companies House and make sure it's kept up to date. So basically, the Companies House public register will replace those internal registers that the company used to maintain. So Companies House has now updated all its guidance and related forms. So do please make sure that you're using the right ones when you make a filing, because it'll be rejected if you're still using the old forms. Right, okay, let's get into those cases now. So first up, the High Court has considered some common commercial contract warranties in a share purchase agreement, providing a bit of useful guidance on how those reasonably standard warranties might be interpreted. So this case involved the acquisition of an IT consultancy company from its original founder and other shareholders. Now, the share purchase agreement contained various warranties relating to the contracts that the target company had entered into. And after completion, the buyer brought claims against the sellers for breach of 2 of these warranties. So, firstly, there was what I'm going to call a performance warranty. And that said that none of the target's contracts were incapable of being fulfilled or performed by the target on time or without undue or unusual expenditure of money or effort. So basically, the target's going to be able to perform the contracts it's already entered into. Now, the buyer said that actually the target's contract that it had with the National Audit Office put it in breach of that particular warranty. And then there was what I'm going to call a customer warranty. So this warranty said that the target had not been materially affected in an adverse manner as a result of the loss of a significant customer. Now, here the buyer said that actually the seller's failure to disclose the loss of a contract with Aquila Air Traffic Management Services Limited shortly before completion meant that the target was in breach of that customer warranty. The other thing that's relevant that was in the share purchase agreement was a clause that said that the warranties would be qualified by matters fairly disclosed with sufficient detail to identify the nature and scope of the matter disclosed. So, a reasonably common standard of disclosure, a reasonably common reference to disclosures against the warranties there. And like I say, actually, those two warranties, the performance warranty and the customer warranty, reasonably common warranties that you find in a share purchase agreement. So, when it came before the court, in relation to the contract with the National Audit Office, the court found that this was a major fixed price public sector contract with tight deadlines, significant risks. There were substantial internal concerns actually at the target about its ability to deliver that contract on time and within budget. And there was evidence that the staff were stressed about it, that milestones had been missed, and that there was a need for significant free of charge work to actually get it across the line. Now, the judge said that meant that in breach of the performance warranty, the contract could not readily be performed on time without undue or unusual expenditure. So basically, in order to get that contract done, there was going to be a need for some undue or unusual expenditure. Thinking about the disclosure point, the judge found that although the sellers were aware of the problems with this particular contract, they hadn't disclosed it to the buyer. The disclosure letter did contain an extract from a RAG report relating to that contract showing reduced profit margins, but the judge said, well, that doesn't amount to fair disclosure as required by the agreement. The information that had been provided was insufficient for a reasonable buyer to identify the true nature and scope of the problems. And the other hurdle that the sellers faced here was that the requirement for disclosures to be in the disclosure letter or the data room meant that oral disclosures that the seller said they'd made at a pre-completion meeting between the parties were not sufficient to adequately disclose the issues. Okay, turning then to the second issue and this Aquila contract, the court had to decide here whether Aquila was a significant customer. Now, the agreement contained a list of the company's top 10 customers by annual value of sales, and that didn't include Aquila, so it isn't in that top 10 list. But the judge said that a significant customer, which was what the warranty referred to, wasn't limited just to those 10 customers, but that actually it included any customer whose loss could materially affect the business. And Aquila was found to be a significant customer given the size of the contract, its contribution to the target's projected revenue, and its strategic importance actually as a new client in a growth area. So the other issue here was that the sellers argued that basically losing that contract with Aquila was just churn or normal business risk, but the judge rejected that argument. Instead, found that the loss of Aquila as a customer was both significant and likely to have a materially adverse effect on the company's business. And again, the sellers had failed to disclose the loss of that contract in the disclosure letter, meaning ultimately that there had been a breach of the customer warranty in the share purchase agreement. So, like I say, some reasonably standard warranties there, but always useful and interesting to see how they're going to be interpreted by the courts, although with the usual caveat that the court is interpreting them in the context of the particular facts and circumstances of the relevant case. I think here this case highlights that the warranties about ability to perform contracts are not just limited to profitability, and qualitative factors, so things like the level of effort and risk required to perform those contracts, can also be relevant. Also, even in industries where some degree of customer churn is normal, the loss of a customer can be a breach of warranty if the business is going to be materially affected. And then again, in relation to the disclosure point, to be effective, as a defence for warranty claims, your disclosures have got to meet the required standards set out in the agreement. And if that requires fair disclosure with sufficient detail in the disclosure letter, then vague references in the disclosure letter or oral disclosures outside the disclosure letter are not going to be enough. Okay, so moving on, but sticking with share purchase agreements. So the next case required the court to interpret restrictive covenants in a share purchase agreement, and in particular to think about whether lending money to a competing business resulted in the person lending the money being concerned in that business in breach of the relevant restrictions. So the background facts here are that in December 2022, the founder of a manufacturing business sold his shares to a private equity-backed bidco, but the founder stayed on as a non-executive director post-completion. Now, the sale agreement contained a restrictive covenant under which the founder agreed not to be engaged or concerned or interested in a competing business within a defined area for a period of 3 years after completion. And then that was in the sale agreement, but the related investment agreement contained similar covenants that applied for 2 years after the founder ceased to be a director or a shareholder. So the key words here, we're thinking about what does it mean to be engaged or concerned or interested in another business, okay? Now, Bidco alleged that the founder had breached the restrictions by providing assistance to two rival businesses. Now, what the founder had done was, in one case, he'd provided €150,000 worth of working capital to a Spanish company, and he also provided advice and assistance to that Spanish company in sourcing products. That included giving the Spanish company supplier contact details and also misrepresenting it to one of those suppliers as being a sister company of the former group. So he was sort of suggesting that there was a connection between the Spanish company and the former group that he'd sold. And then the other thing that he did was he helped a UK business by providing that UK business with advice, including about how to price certain products. Now, each of these two businesses, the one in Spain and the UK one, had been set up by former colleagues of the founder. And he argued that in assisting them, he'd been motivated not by self enrichment, so, trying to make a profit for himself, but actually by what he termed generosity of spirit and sympathy for his friends because he thought they had been shabbily dealt with by the new management once the group had been sold to the PE backed entity. So, like I say, what the court had to do was decide whether the founder's actions meant that he was engaged, concerned, or interested in the competing businesses in breach of the restrictive covenants. So the judge had to think about what do those words mean. And he said that being engaged in a business involves carrying on or transacting the business, and being interested in a business generally involved having a proprietary interest in it. So simply lending to a business didn't involve either of those things. But was the founder concerned in the rival businesses? Now, here, the judge said that a person who lends funds for use in a business was capable of being concerned in that business within the meaning of the restrictions. He said that the founder's activities had to be assessed as a whole. And if lending money or other assets is coupled with other activities to support or assist or intervene in the business, then the lender of the monies will likely be found to have become concerned in that business. Citing comments that had been made in a previous case, the judge agreed that there is no more effective way of being concerned in a business than by providing the capital necessary to establish it. So, based on the founder's actions in providing assistance and information and advice to the Spanish and UK businesses set up by his friends, the judge found that he had breached the restrictive covenants on multiple grounds. And the judge also found that those same actions that the founder had been doing constituted breaches of the fiduciary duties that he owed as a non executive director. So, anyone signing up to restrictive covenants has to understand that being concerned or interested in a business does actually extend beyond just direct ownership or employment. Simply becoming a creditor might be permissible in some circumstances, but as soon as you provide any other advice or assistance or you're further involved, then you're likely to be crossing a line and triggering a breach of covenant. The threshold for being concerned or involved is pretty low, really. So things like, in this case, sharing supplier lists, providing pricing advice, leveraging former goodwill. So, that claim that a new venture is a sister company, all of those things could be fatal. And also, another really key point, the legal test is just an objective one. So just because, you're motivated by sympathy for friends or former colleagues, whatever, that is not going to negate a breach, regardless of how altruistic your intentions are. Okay, final case. So this one relates to directors' duties and unanimous shareholder consent, so the geomatic principle. Now, this is a Privy Council decision where the court held that a former director had breached his fiduciary duties by transferring company assets to himself and others without shareholder authority. And the court confirmed that for informal shareholder consent to be valid, that consent doesn't have to have the key features of a binding agreement, but there must be clear, informed, and unanimous agreement by all the shareholders entitled to vote. I said it was a Privy Council decision. Now, the Privy Council acts as the final court of appeal for various Commonwealth countries and overseas territories. Actually, strictly, its decisions are not binding on English courts, but the principles that were discussed in this case are substantially the same as under the laws of England and Wales, and therefore I think this decision is likely to have persuasive value in the UK. So I think it's worth us thinking about it. Now, I've already referred to the geomatic principle, so quick reminder of what we mean by that. That allows a company's shareholders to make decisions through informal, unanimous consent. And it states that where all shareholders who would be entitled to vote on a matter at a general meeting give their unanimous and informed consent to a matter, then that consent is as binding as a formal resolution. So basically, if they all consented informally, there isn't really any point in requiring them to go through a formal process, to repeat a formal process, and you can treat that informal consent as valid. That principle can be invoked, has been successfully invoked in a wide range of circumstances, but there are some limits on its scope. So, for example, it can't be relied on if there's evidence of fraud or if the matter is otherwise unlawful or beyond the legal powers of the company. So that's what we're talking about, Privy Council decision, and we're looking at geomatic principle, unanimous informed shareholder consent. So our facts here are we've got a BVI company, so that's how come we ended up in the Privy Council. So we've got a BVI company that had been incorporated solely to effect an employee share benefit scheme for 3 key employees. Now, the shares in that BVI company were held equally by 2 shareholders, Delco, which was a Dutch company, and then another BVI company called HWH, which was owned by a Mr. Fang. Now, Mr. Fang and the 3 key employees were appointed as directors of the BVI company, and 2 of the key employees were related to Mr. Fang. So the BVI company sold its primary asset, which was shares in another company, for 150 million Hong Kong dollars. And the proceeds of that sale were paid into Mr. Fang's personal bank account. So it's the company that sold an asset, but the proceeds went to Mr. Fang's personal bank account. Remember, Mr. Fang is a director of the company. The company's board hadn't approved the payment to Mr. Fang, and neither had Delco, one of the shareholders, been informed about it. Mr. Fang subsequently distributed the proceeds of sale from his personal account to the key employees, which remember are his fellow directors, in equal shares. Now, when the company went into liquidation, the liquidators brought proceedings against the former directors. They alleged that Mr. Fang had, without authority, diverted the share sale proceeds to himself and then wrongfully distributed those proceeds to the other directors. The BVI High Court agreed with the liquidators and held that Mr. Fang and the other directors had acted in breach of their fiduciary duties. The court rejected the directors' argument that the company shareholders had given their informal assent to the payments. So there was then a failed appeal to the BVI Court of Appeal. So Mr. Fang and HWH, one of the shareholders, appealed to the Privy Council. And their appeal focused on whether the payments by Mr. Fang to the other directors were in breach of his duty to exercise his powers as a director for their proper purpose. And if so, whether those payments were still validly authorised by unanimous shareholder consent under the geomatic principle. So the Privy Council rejected Mr. Fang's appeal and it upheld the decisions of the lower courts in the BVI. So on the issue of the directors' breach of duty, the Privy Council confirmed that directors may not pay themselves from company assets without prior authorisation. So it rejected the argument that as the company's sole purpose was to deliver the employee share scheme, then any action taken by Mr. Fang to implement that purpose, such as distributing the sale proceeds, had effectively already been authorised. The court said, well, that argument just ignores the fact that actually key elements of the share scheme, such as the price that had to be paid for the shares, you'd think that would be a pretty key element, still required shareholder approval, and the directors didn't have authority to decide those matters themselves without that shareholder approval. So essentially, without valid shareholder consent, Mr. Fang and the other directors had acted in breach of duty by distributing and receiving the proceeds of the share sale. Now, in relation to the actual shareholder authorisation, the Privy Council acknowledged that Delco and HWH, remember the two shareholders, could have unanimously and informally authorised the directors' actions by relying on the geomatic principle. But crucially, on the facts of this case, Delco, one of the shareholders, had not approved the retention by Mr. Fang of the sale proceeds or his subsequent payments to the other directors. The shareholders had agreed that the company would be used to provide an employee share scheme, but all the other details in relation to the scheme were still to be agreed. The Privy Council also confirmed that consent given in accordance with the geomatic principle doesn't have to have all the particular features of a binding contract. And the Privy Council was a little bit critical of the trial judge because the trial judge had referred to things like creating legal relations or being legally enforceable when describing unanimous consent. So kind of transposing some of that language that we see around legally binding contracts to the shareholder unanimous consent. But giving the judge the benefit of the doubt, the Privy Council basically said that what he meant to say was that the shareholders intended to bind themselves legally as if they had passed a formal resolution. So that's what the shareholders need to be thinking about, and you don't need those other elements of contractual formation. So let's think about that. What are the lessons here? So I think for directors, it's a good reminder of the importance of specific authorization if they intend to transfer company assets to themselves or to any connected parties. Failing to obtain that clear authorization will almost certainly mean that a director is in breach of their duties to the company. And as we can see, that could result in the director being required to account to the company for any sums they receive. Obviously, best practice would be for the shareholders to pass a formal and properly documented resolution authorizing the relevant actions. But if they're going to be relying on informal consent under Duomatic, then they must be able to demonstrate that all eligible shareholders agreed to the specific mechanics of the transaction. You have to have certainty about what it is that the shareholders are actually agreeing to, even if they're agreeing to it in an informal way. So there we go. That's it for this month. Hope you found that interesting, and I'll speak to you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.